Welcome to This Constitution. My name is Savannah Eccles Johnston.
And I'm Matthew Brogdon.
And today we're going to talk about impeachments. But we're actually going to talk about impeachments over two different episodes. Today we're going to focus just on judicial impeachments. But first, we want to clarify how the impeachment process works. This is a constitutional process, and let's figure out who does what in this process. And it's important to note here, when we're talking about impeachment is different than conviction, but we tend to lump these things together. So, impeachment starts in the House of Representatives.
That's right.
Right. Okay, so give us the constitutional basis for this.
The Constitution says that the House shall have the sole power of impeachment. And that sounds like they're doing a thing by themselves.
Right.
But really, if this were a legal process, we'd say this was the stage of indictment.
Right.
Like where you're bringing charges.
Right.
And identifying what you think the person's guilty of, and that there's a reasonable basis for thinking that, but it doesn't actually finally decide whether they're guilty or not.
Right. And all you have to do to get this indictment is get a majority. Simple majority in the House. So it's not a very high bar. But then the actual trial occurs in the Senate, and there you need 2/3, and presiding over the proceedings is the Chief Justice of the Supreme Court, and you have managers from the House of Representatives who will present the case of the House. Basically, this is the evidence, and then whoever is being impeached, or is on trial, I should say, has their defense lawyers there.
So when you think managers, House managers, think prosecutors.
Right.
Right, in a trial. And that means, what is the rest of the Senate in this process? If you've got a defense counsel, looks like a trial.
Right.
You've got some members of the House who are up there pressing the case as prosecutors. You've got somebody presiding, which if it's the president, has to be the Chief Justice of the Supreme Court. Could be the Chief Justice anytime this happens, I guess, if it wanted, but it has to be if it's president or some other presiding officer. So who's the rest of the Senate playing in this
the jury.
This theater, this play?
Right, the jury.
They're the jury.
They're the jury. And
but a jury that can ask questions, right? So this is how I'm not as familiar with this. I'm a little ashamed to say I have not closely watched a lot of impeachment proceedings. I'm not a big fan of political theater. And so I haven't watched as many hours of tape on this as some folks have. So did the members of the Senate get to ask questions?
So in the most recent Trump trial, they did not ask any questions.
Okay.
It was just presentations by both the House managers and by, in this case, Trump's defense attorneys. Though this is set up like a criminal trial, it's important to note that this is a political process. This is not a criminal process, meaning no one's going to jail at the end of, when we say conviction, all we mean is the most that can happen to you is you will be removed from office and potentially stripped of the right to ever hold a position of trust in the United States again. Yeah. Purely political consequences. No one's going to jail here. It's separate from the judicial process.
Yeah, I ran across this provision that I always forget exists when I was sort of scanning the Constitution for these provisions. And it's in Article 3 under the jury trial requirement.
Okay.
In Article 3. It says, the trial of all crimes, except in cases of impeachment, shall be by jury.
Right.
Which is interesting. It's, they felt like, if we didn't say that, people might actually think, you got to have a jury trial for impeachment too.
Right.
And you do kind of, but the Senate's the jury. You don't go get a jury from the community like you normally do.
Right. Because impeachment is, in the end, one of those checks and balances powers. It's one of those weapons that Congress has against all executive officers of the United States and all judicial officers.
And you say it's political. Actually, the history of how the clauses got where they are in the Constitution sort of affirms that, because when the convention is trying to write up the jurisdiction of federal courts early on, actually one of the things listed alongside admiralty and maritime cases and cases involving the revenue was cases of impeachment were originally part of federal jurisdiction to be conferred on the federal court. So just imagine if, in our system, removal from office was prosecuted in the courts of law. And you're shaking your head because it's hard to imagine, and they switch it precisely for this reason, because they think, actually, this is too political to hand to a judge. On what basis is a court going to make these kinds of decisions?
Right, because this is an inherently political question. So what's interesting is when we think about impeachments, we think about presidential impeachments because those are the ones that eat up all the airwaves. But we have not had a single successful presidential impeachment and conviction in our history. In fact, all of our successful impeachments leading to convictions have been in cases involving judicial officers. It's been judges. So we've had 15 impeachments by the House of Judges and 8 convictions. We've had 0 convictions for anyone who is not a judge. So really the development in the thought on impeachment comes from judges or trying to kick judges out.
Which is weird, because you would think if you had shenanigans that you're going to have to remove people from office for, wouldn't you expect it out of like cabinet officers and executive officers and stuff? Why is it judges? Why are judges getting in so much trouble?
Well, and so what's great is so many of these cases are about corruption, bribery, and then perjury, lying about that corruption and that bribery.
Is it that there's no corruption in the executive branch? Is that
maybe it's just more tolerated? I don't know. What is it?
well? Also, I mean, you can fire people in the executive branch.
That's
I mean,
true.
like the president, if somebody's taking bribes or misbehaving, presumably they're, the cabinet secretary that's over them or the president himself can them. I mean, we fire cabinet secretaries on a fairly regular basis.
Right.
I don't know what the number is. I wonder if we compared the number of cabinet secretaries who have been fired versus the number of judges who have been impeached.
Oh, way more have been fired.
Yeah, and I bet it's a lot more. Although maybe not for bribery, just maybe
No.
for being stupid or
Right.
disagreeing. But
But this is actually a really important point. The only way to get rid of a federal justice outside of them resigning or dying is impeachment. So
That's right.
This is it. This is the only method.
it is peculiar that in the debates over the Constitution, whenever it was being ratified, people who were defending the life tenure of judges, in effect, actually refused to call it life tenure. Alexander Hamilton is super careful in Federalist 78, which is technically about defending tenure during good behavior.
Right.
Says it's not life tenure, it's tenure during good behavior. And he thinks that's really meaningful, that you only get to hold this office as long as you behave yourself. And there's a way to get rid of you if not. So the way that the framers and the people engaged in the ratification debates talk about this suggests there's real teeth in impeachment.
Right.
Yeah.
So let's talk about some of the controversies over impeachment that really impeachment trials of judges have given us. And the first is, we've kind of answered this, does impeachment and conviction require a previous criminal conviction? And of course, our early argument is no, because these are separate processes.
Yeah.
But it's something that we first figure out in the case of Samuel Chase, and then getting to a delightful character named Alcee Hastings. So let's start with Samuel Chase.
Let's start with Chase. Chase is interesting. Chase's impeachment is actually connected to Marbury versus Madison in a weird way.
Okay.
So we talked about Marbury versus Madison as this big political / legal fight between the Marshall Court and the Jefferson administration, with Marshall representing Federalists and Jefferson obviously representing Jeffersonian Republicans. And the Chase impeachment is kind of a continuation of that fight. That they were all, the Chase impeachment, Marbury, are all episodes in a struggle that comes out of the election of 1800, where Jeffersonians, they run the board. They
Right.
win both houses of Congress and the presidency. And they do a really controversial thing when they get in. They repealed a Judiciary Act that had created 18 new federal judgeships. So Federalists sort of going out the door, they've been exiled into the wilderness. They, going out the door, create a whole host of new federal judges, reform the federal courts in ways that were actually needed, but they do it at the last minute, and then Adams gets to appoint these midnight judges, right?
Right.
So Jeffersonians wind up repealing this. And the controversial thing about it is, by repealing the act, they effectively removed 18 federal judges from office.
Right.
Without the dignity of impeachment. These were people who were supposed to have tenure during good behavior. So a lot of Federalists think this is unconstitutional.
Right.
And it obviously was. But Chase is the most sort of rabid Federalist. He's the most partisan Federalist in the federal judiciary. He's on the Supreme Court. And he actually spends a bunch of time writing letters to other justices after this repeal happens, trying to get Marshall and the other justices to help him get a case in front of the court where they can declare the repeal of the Judiciary Act unconstitutional.
Okay.
And he can't do it. The best they can do is to get Marbury versus Madison in front of the court, which doesn't really address the big issue. So Chase is unhappy. Marbury was weak sauce. It did not get the job done, did not get a chance to tell Jeffersonians they'd done this unconstitutional stuff and undermine the judiciary. So he gets pretty hot on the bench. He actually reads a grand jury charge sitting on circuit. One of the important things Supreme Court justices did was ride circuit around the country and hold circuit courts. And he reads a charge to the grand jury on circuit. I think it might have been, I hesitate to say this, I think it might have been Maryland or something. But he reads this grand jury charge in which he just lays into Jeffersonians about all the unconstitutional things they're doing. It's like a stump speech for why the whole Jeffersonian platform is destroying the country and the things they've done are unconstitutional. And this really ticks off. Grand jury charges from federal judges were often printed up in newspapers and things. They often were not just like legal documents. They were sort of like often political speeches, although traditionally they were times when a federal judge would get a chance to sit in front of these ordinary citizens out somewhere in the country and sort of explain to them their legal system, their principles of government. They often had a sort of civics element to them. Well, Chase has made it into this big partisan thing. And Jeffersonians think this is really, when you put this together with some of his more obnoxious behavior on the bench, he would sometimes harass lawyers, refuse to let them present evidence or make legal judgments before they'd even had a chance to talk.
Right.
They thought all this adds up to somebody who is guilty of misbehavior. You have tenure during good behavior. This is not good behavior. We're going to kick you off the bench. So the House brings an indictment, a bill of articles of impeachment, enumerating a bunch of these things. So that's how Chase gets impeached. But he doesn't get convicted.
Right.
So why doesn't he get convicted is the question. Like, he's been obnoxious, clearly. Why didn't they boot him off? Not to mention, by the way, another important piece of information here is in the Chase impeachment, Jeffersonians have 25 seats in the Senate, and Federalists have 9. 25-9.
Right. Should be easy.
Should be. This should be open and shut. They've got, 2/3 easy.
Right.
So why doesn't he get impeached?
Well, he's going to make the argument that there's been no criminal conviction.
I didn't break the law.
Right.
Sure, I'm a partisan hack. You don't like what I said, but I didn't break the law.
So he doesn't get convicted.
He doesn't. It fails. He manages to convince like 5 Jeffersonian senators to vote against impeachment.
Right. But this is not the final word on criminal conviction and impeachment. We fast forward to...
By the way, can I just say,
yes.
I think it's a little unfortunate that they didn't seize the opportunity to do this. Because had they impeached Chase, it would have telegraphed to the court that, no, if you act like a partisan hack on the bench and wade into politics,
it's misbehavior.
We will kick you off. You need to keep acting like a judge and convince the public that you're being judicial and not running for office, or we'll remove you.
Right, which goes to a question of there's a distinct character about the judicial branch. It has to be in some way less political.
And Congress missed its chance to...
Right, they missed that chance. So moving forward all the way until the 1990s, we get Alcee Hastings.
On this show, you have to specify.
Right.
When we say 90s, right? 1790s, 1890s, I mean...
1990s.
Occasionally, we might even be talking about English common law, and it might be the 1390s or something. You never know.
So we've got Alcee Hastings, and he is a federal judge in Florida, because of course it's Florida. And he has been... don't worry, I've got more Florida jokes coming. So he is...
This is my home state.
I know,
okay.
that's why this is coming.
Thanks. That's fine.
So Alcee Hastings, is a judge who has been accused of bribery and corruption and then lying about it under oath. This goes to the House, and they impeach him. Then it goes to the Senate, and he will make the argument, like Samuel Chase in the Senate, there has been no criminal conviction. So you don't have the authority to convict me in the Senate and remove me from office. Around this same time, you have Nixon versus United States. So this is not Richard Nixon. I think his name is Walter Nixon, right? Walter Nixon, in which the court takes up a similar question here and basically finds that you don't need a criminal conviction for the Senate to exercise its conviction powers. So the Senate takes this and says, you are going to be convicted and removed from office, but they decline to also find him unfit to hold a position of public trust again in the future. So he's only given that half conviction. So he's removed from office. He's no longer a federal judge.
Not disqualified.
He's not disqualified. He will then go and run for a House seat from Florida and hold it for the next 20 plus years until his death. So he kind of wins in the end, I guess, because he's not disqualified, and I guess Florida has vindicated him.
I guess that's winning.
Florida likes these kinds of people.
You know, this is the thing. People talk about name recognition in elections.
There you go.
Yeah, I think Hastings won on name recognition.
Oh, you think it's name recognition and not, we kind of like the spirit of a man who can have the gumption to run for office again after
I
being
don't
convicted.
know, but in the interest of defending the honor of my state, I'm going to say it was just ignorance and not, like it was like, hey, we've heard of him.
We know that guy.
He's kind of famous, and maybe the other person in there just had a really weird name that they didn't recognize, and they thought, Hastings, that sounds Alcee Hastings. This sounds like someone who should be in public office.
Right. And then once he wins once, then you've got the incumbent advantage.
The incumbent advantage. And I don't know. People don't read the newspaper.
No. So Alcee Hastings and this United States versus Nixon versus the United States.
Oh, by the way, we should say it is important to know that districts do sometimes do this, though, because they did it with who was it from Harlem back in the 60s? Had the Supreme Court case about him.
I don't know. It only sticks out in my mind when it's
Florida.
Florida.
he had been the House refused to seat him because of corruption in the use of his funds, and his district reelected him anyway. Yeah.
That's delightful. Okay, so this...
William Clayton Powell.
I'm impressed
this
you remember
Powell
this.
versus McCormick.
Oh, I'm impressed you know this. So this answers the question for us. Do you need a criminal conviction prior to impeachment? Now, what's interesting is, as we'll talk about next episode, when this comes to the two impeachment trials of Donald Trump, this is again an argument that's made. You need a criminal conviction before you can, it's an early argument, a criminal conviction before the Senate can convict him.
Or
and
at least
you can point back to Alcee Hastings and say, no, you don't. This is pretty settled at this point.
Yeah. The somewhat moderated argument is you at least have to be subject to criminal, like you're accused of doing something that could be indicted after you do leave office.
But I don't even think that's true necessarily. So, and that leads us to our second question, which is, can you impeach justices just because you don't like their rulings? Nothing that would rise to the level of criminal behavior, nothing like that. This is really pushing it, saying impeachment is, in this case, a purely political tool, the only political tool that Congress has to rein in the federal judiciary. Therefore, can you fire judges? Can you impeach them just because you don't like their rulings? And this is a modern issue. You have President Trump calling for impeachment of judges who made rulings he disagreed with, and you have the Chief Justice of the Supreme Court saying it is long established precedent that you cannot impeach justices just because you don't like their rulings. That
because
doesn't
you disagree
qualify.
with their decisions.
Right.
Yeah.
So what do you think?
Also, I mean, maybe we should acknowledge like the argument for this is grounded kind of in the language of the Constitution, as the idea that there's got to be something criminal about their behavior. Because Article 2, Section 4 says the President, Vice President, and all civil officers of the United States, so this would be anybody who's not a member of Congress and who's not in the military, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors.
Right, but that high crimes and misdemeanors is not in any way defined. We know what treason is, and we know what bribery is. We don't know what high crimes and misdemeanors are.
Yeah, but I think people now go, oh, misdemeanors. No, those are I know what those are. That's like,
Right.
shoplifting,
Right.
isn't it?
But again, we separate these
But
processes.
that's not what it meant back then.
No.
Misdemeanor, like, literally means to misdemean oneself, means literally to misbehave.
Right.
And in this sense, like the Article 3, when it says that judges shall hold their offices during good behavior,
Right.
good behavior is just the opposite of misdemeanor.
Right.
You can misdemean yourself or you can behave well. Like behave badly, behave well. This is actually the alternatives. But some people do argue that these are sort of terms of art that have to be understood as being some kind of violation of the law. Mm-hmm. Like you did something illegal that you could face some kind of consequences for. And I do think that faces a sort of uphill climb whenever you think about what the language actually means. Like there are lots of ways you could betray the public trust
Right.
and misbehave yourself in office and do the public interest a lot of damage
That
aren't just sort of poor judgment, but actually like malicious intent or, I think we should sort of maybe answer the questions. This including competence. Like if you just really bad at your job,
Right.
it's hurting the public interest.
Right.
Why not say that's misbehavior? Like
Right.
being bad at your job.
Well, there's two other complicating factors here. And again,
Okay.
one is, which we've already mentioned, this is the only way to get rid of federal judges, is through impeachment. Therefore, it can't be an exclusively legal process when you're talking about good behavior. And second is, what are the consequences of impeachment? They are not legal consequences. You're not
Right.
going to jail. The worst that happens to you is you lose this position of trust. You lose a political office, and potentially you're barred from ever holding a political office again. The standards for what it takes to be convicted in a criminal court and what it takes to be convicted in an impeachment trial are thus very different standards.
Right. And even the conviction procedure, I mean, we get a few indications of that in the text.
Right.
When it gives the Senate the power to trial impeachments, it tells us that conviction of impeachment doesn't extend further than removal from office or disqualification from future office holding. And it doesn't preclude additional civil or criminal prosecution.
Right.
So you can still, just because you got removed from office for taking a bribe, you can now be indicted and tried for taking a bribe
Right.
separately and face the criminal consequences of that, or sued by some person who was harmed.
Right. But the key is it's a separate process to determine those legal ramifications. So, but that's all fine and good. This is kind of the theory of it.
Also-
But
well-
in application, it feels kind of messy to remove judges based on potentially the political ramifications of their rulings.
So, I mean, can you give any definition of that? I mean, you're suggesting that high crimes and misdemeanors or failing to exhibit good behavior is kind of a political, not a legal standard. So is there any boundary to it?
I don't know. I think potentially the answer is no. It's only kind of historical precedent and what Congress is willing to drag itself into.
There's an institutional limit that says, well, if you can convince 2/3 of the Senate
Yeah.
to convict,
Something
then I guess
which-
it was good enough.
Right. And by the way, that 2/3 is a remarkably difficult thing to do. I mean, it's only happened 8 times in our entire history. So that itself seems to be the only necessary limit.
And in Chase's case, it even failed when the one party had the votes.
Right.
They lost voters. This happens again with we'll talk about it in the next episode, but it's going to happen again when Republicans are in control and they can't convict Johnston. So even partisan control of the number of seats is not always enough to get a conviction. You can't even rely on a party line vote.
You know, when Hamilton speaks about this in the Federalist Papers, is that impeachment is so difficult because you can't rely on just your faction. You need to have kind of cross-factional support for conviction.
So just an aside, I mean, some people do claim that impeachment's not the only way to get rid of a federal judge.
You're going to bring this up?
Yeah, I'm going to bring it up real quick. But there was actually a method in England for like a superior court removing judges of a lower court, and the standard was good behavior. They could issue a thing called a writ of scire facias. It's hilarious. To remove the lower court judge if they were guilty of misbehavior or misdemeanor on the bench. And some people have argued that when Article 3 says judges hold their offices during good behavior, it means the Supreme Court could reach out and just remove a lower court judge who's misbehaving.
And in turn, could the lower court justices remove Supreme Court justices?
No, because it would always be a writ that flowed from a superior court to an inferior one. So that would mean this would not be a means of controlling Supreme Court justices. But it has actually played a role because at various times people have suggested that one thing we should do in the federal judiciary is empower the Supreme Court to discipline lower court judges. And in fact, our very first successful impeachment of a judge, which was John Pickering, who's a federal district judge, who actually, poor guy, was losing his mind.
Okay.
But also was tended toward drunkenness.
Oh.
But the biggest problem was he was losing his grip on reality. His mental faculties were slipping in a very significant way. And this was affecting, it was like writing limericks into decisions or something and sort of doing wild things on the bench. His clerks actually wrote to the Supreme Court and to the president and said, you've got to replace him. And they actually sent a circuit judge to go take his place on the bench and sort of relieve him of duty. So he remained a judge, but they took his caseload away and gave it to this circuit judge.
Right.
But then the circuit judge went away whenever the Repeal Act went through, funny enough. And so they had to impeach him, but they wound up in the impeachment proceeding. He hadn't actually done anything legally wrong. It didn't even seem like he had done anything malicious. It was just his mental faculties were slipping and he couldn't do his job. They actually wanted him to resign and he refused.
Right.
So they had to impeach him on the ground of incompetence.
Right.
So this was one of those cases where actually a lot of people have looked at this and said there actually ought to be a way for like the Supreme Court to identify cases where judges are incompetent and remove them or discipline them in some ways.
Right. But for now, there
but
is
we
not.
don't. We've never. That's always been a constitutional debate, and people have pointed at the Constitution and says no. That good behavior thing is talking about impeachment.
Yeah.
So we haven't gone that route, but we could.
Well, getting back to impeachment and just how kind of freewheeling you can be with impeachment when it comes to judges for misbehavior and how you define misbehavior, there is a fine balance you have to strike here between judicial independence and oversight by Congress on the judiciary. And again, the only way to remove justices is through impeachment. So how do you balance impeachment with judicial independence? And maybe your answer is the Senate sets such a high bar, 2/3 of the Senate sets such a high bar that does it for us. But there is a balance that has to be struck here.
I mean, this is a self-imposed restraint on the Senate. I don't think there's any way to appeal a decision of conviction in a case of impeachment. Though we'll get in our next episode. We're going to have to talk about what happens if a president thinks something's been gone awry. But if the Senate convicts, there's no real appeal from the Senate's decision. It's final. So if you can convince 2/3 to convict, I guess that's it. And so to the extent that there's any kind of limitation where they go, well, that's not a good reason or that's not a good enough reason, it's totally self-imposed. It's a matter of self-restraint. There is actually the maximalist position on this being a political power would say, well, let's just say we thought if a judge goes so far off the rails in their legal opinions that they're construing the law in a way that 2/3 of the Senate thinks is destructive to the public interest and just wrong. The judge is just wrong about the law. They're deciding cases in ways that are hurting the public and distorting the Constitution and distorting our laws. If you can convince 2/3 of the Senate of that, is that misbehavior? Is that a failure of good behavior, like basically judicial incompetence? Your interpretation of the laws is so wild and destructive that we think you just shouldn't be a judge anymore.
Right.
Is that a good enough reason? And I'm actually open to the argument that might be a good enough reason. But it's going to be hard, actually, to convince 2/3 of the Senate that a legal opinion is so far wrong. Also,
especially in as divided of Senate as we have today.
Also, I'm hard-pressed to come up with an example of this, like a federal judge that has gotten so carried away in their interpretation of the laws that you could actually convince people, that many people, that they're just kooks. We say this, like we had the whole impeach Earl Warren thing
Right.
for a decade. And now, you've got Trump and others saying
Right.
impeach Jim Boasberg.
Right. And you have movements to impeach
Yeah.
Alito and Thomas.
But actually, the legal opinions they're objecting to are actually held by a very large number of people.
Right.
So it's hard to argue they're just outside the Overton window,
Right.
like just completely outside the realm of acceptable opinion.
Right. So this brings us back to how do you balance judicial independence with the impeachment process? And the answer is it's kind of self-balanced. The only function you need is the Senate. Maybe Hamilton was right on this, that this is all you really need is that 2/3 marker. Not that I know of, do we have a single conviction of a federal judge for purely disagreeing with the way he has construed the law. So we've never actually kind of crossed that line. It would be very hard to cross that line. But nevertheless, the only times we've ever used impeachment have been for federal judges.
Do have a couple for being drunk.
Right. Well, that counts.
That counts.
Yeah.